So I want to try very briefly to suggest two things to you. The first is that we should be grateful for the constitution we've inherited, which is a constitution relying at its heart on democratic politics to direct and to discipline public power. And here I have in mind the relationships and the processes that I understand Meg spoke to you about this morning. The second thing I want to suggest is that we should be concerned about the rise of judicial power in our constitution, a trend that seems to me to threaten to undermine democratic politics. If I'm right about that, which of course is for you to decide, two more particular conclusions seem to me to follow. The first is that we should hold on tightly to parliamentary sovereignty, not let it slip away. And second, we should take some steps to restore some of the traditional limits on the role of the courts in our constitution. The UK has a very similar constitution to that of New Zealand, where I was born and raised. It's a constitution that centres on parliamentary sovereignty, responsible government, and the rule of law. In other words, Parliament's free to make the law as it sees fit, the government needs the support of the House of Commons and the electorate, and the courts apply the law of the land in resolving disputes, including disputes between citizens and government. Now, many people in Western democracies are dissatisfied with their governments and with politics at large. However, in historical perspective, the UK has a pretty good record of decent government. People disagree, of course, sometimes quite fiercely about how we should be governed, but that's partly the point. In our constitution, this disagreement is settled fairly by the political process. Many lawyers like to complain about our constitution, wishing it was rather more like the American constitution, strict separation of powers and a much stronger Supreme Court. That's always seemed just a little bit crazy to me. I can't really see how one could think the United States is better governed than the UK or Australia or New Zealand. The oversized role that courts have come to occupy in American public life seems to me something we should avoid rather than copy. Well, who decides in the end what our law should be? In our constitution, the answer has always been Parliament, not the courts. The courts are not well placed to make good decisions about what the law should be, and it's very difficult to hold judges to account for their lawmaking decisions. Now, some people will say that might be true in general, but it doesn't hold when human rights are in play. I disagree. It's always been the case that Parliament should think carefully before legislating. Some legislation would be unjust, unfair, or simply unworkable, and it shouldn't be enacted for that reason. The idea of human rights captures part of this truth, pointing out part of what we owe to one another. But the idea of human rights can't do away with disagreement or with the need to choose. In a democracy, it should not be for the courts to question or to overrule Parliament's choices. The way to reverse legislation is to persuade a later Parliament to change the law. Well, as Chris will have explained to you this morning, the Human Rights Act and the European Convention on Human Rights give judges a role in reviewing the merits of legislation. Strictly, our Parliament is still free to make the law, even if judges disapprove. However, human rights law often ends up limiting Parliament's freedom in practice, as one can see, for example, in the context of legislating about immigration and asylum. Some judges have threatened simply to strike down legislation they think is unjust. In other words, they've threatened to declare that some acts of Parliament are not actually laws at all. I think the law of the land clearly forbids them from doing this. But would it be an improvement for our constitution if they had that power? Not at all. It would give the Supreme Court the final word about what our laws should be, despite the fact that people have no control over the court. In my view, then, Parliament should not be subject to judicial control. But the position is obviously different in relation to the government. We need independent courts to apply the ordinary law to ministers and to civil servants. As Chris will have noted this morning, we also need courts to stop ministers going beyond the scope of their legal powers. And I agree too that courts can usefully help to secure procedural fairness. But judicial review of government action carries with it a risk that the courts may end up deciding what should be done, rather than just supervising the lawfulness of what is done. The risk grows if or when judges lose confidence in the political process and start to think of themselves as the guardians of the Constitution at large. I think you can see the problem in the Supreme Court's judgment about the prorogation of Parliament in September 2019. In that case, it seems to me, the Supreme Court invented new law, deciding for itself what the Prime Minister should have done, rather than leaving this to the political process. That's not the way our Constitution has traditionally settled what should be done, and it's not an improvement. Thank you.